This is Jonathan Lim coming from Just Add Astra, and he's going to be talking about human rights as a foundation for our Mars Bill of Rights. Jonathan Lim, thank you for being here.
Thank you, Danielle. Let me just share my screen. All right, so just get started. Hello, my name's Jonathan Lim. I'm the project co-lead to Just Add Astra. While Mr. Theodore Nastase was intended to join as co-presenter for this session, an unexpected personal commitment means I'll be presenting solo today. So today, as part of the 2020 Mars Society Convention, I'll be presenting on the need for human rights values and principles in creating a philosophical, moral, and legal basis in supporting the advancement of human activities in outer space, serving as the basis for constitution making and the formation of a Bill of Rights for isolated communities across the final frontier. Where 30 minutes has been allocated to this session, I will plan to speak for approximately 20 minutes, and then we'll leave about 10 minutes after for audience questions and answers. Next slide. Yep. So the Just Add Astra project was started in January 2020 as a legal research project under Wise Law, a specialist Australian type law firm. And the project is focused upon promoting broad discussion and analysis concerning the relationship between human rights and outer space. The project has since issued several documents exploring the right to peace and moderating international conflicts in space, the issue of disability rights in space, and the need for the right to a breathable atmosphere. So over the past decade, the proliferation of space technologies under Space 2.0 has seen a decline in the cost of access to outer space. This lowering cost has reignited the public's fascination with space, sparking a revival in space tourism and the possibility of expanded human activities in outer space and on the lunar surface. Over the following decade, contingent upon the promise of regular commercial human spaceflight activities through such companies as SpaceX and Blue Origin, humanity is expected to experience the exponential democratization of outer space. Consequently, space represents a new frontier for the law and human rights. Here in the extension of terrestrial international human rights law, IHRL, values and principles across international space law, ISL, may face novel challenges in managing prolonged and isolated human activities across outer space and upon other celestial bodies. Associated to the expansion of humanity's presence in outer space is a need for laws and guidelines regulating the activities of both government and private entities within this new environment. Questions abound concerning how terrestrial governments will reconcile with the challenges of significant geographical distances and delays in time communication. How will isolated human communities enforce the law? And what responsibilities will isolated centers of authority have to respect, protect, and fulfill the basic rights of their citizens? In response, civil society organizations have promoted the need for a Bill of Rights in space. For example, in 2014, during the second International Extraterrestrial Liberty Conference, Professor Charles Cockle promoted the creation of a colonial constitution for future human rights settlements on Mars. Hold on. Just hold all questions until the end of the presentation, please. So additionally, the Moon Society has also created its own conception of a lunar Bill of Rights. The need for a singular foundational governance document, whether a constitution or Bill of Rights, is founded upon the freedom of space settlers, on how this freedom of space settlers can be incorporated into the governance structures of extraterrestrial settlements, and how governments can offer future spacefarers the greatest opportunity to maximize their liberty in outer space. As a point of clarification, the need for a codified structure of governance across human settlements in outer space should be noted as the need for foundational documents, a term used here to include a constitution and a Bill of Rights. Next slide. So human rights represent rights inherent to all human beings, regardless of our gender, ethnicity, religion, or otherwise. These rights are interrelated, interdependent, and indivisible, reflecting the minimum standards required for people to live with dignity and guaranteeing people the means necessary to satisfy their basic needs, so they can take full advantage of all opportunities. Human rights encompass the following principles: Firstly, the universality of such rights. All people everywhere in the world are entitled to them. Second, human rights are indivisible. The deprivation of one right adversely affects the others. Third, human rights are interdependent and interrelated. The fulfillment of one right often depends wholly or in part upon the fulfillment of others. Fourth, all persons and institutions are accountable to just, fair, and equitable laws. Fifth, all people have the right to participate in and access information relating to the decision-making processes that affect their lives and well-being. Finally, states and other duty bearers are answerable for the observance of human rights. They bear the responsibility to respect, protect, and fulfill their human rights obligations. So in the aftermath of the Second World War, the international community collectively resolved to promote and encourage respect for human rights through international cooperation. Under the contemporary IHRL framework, universal human rights have often been expressed and guaranteed by law in the forms of treaties, customary international law, general principles, and other sources of international law. As listed, this framework is comprised of the International Bill of Rights and subsequent human rights treaties and agreements. In applying these agreements extraterritorially, that is beyond the borders of the state and into the domain of outer space, reference may be had to the International Court of Justice's 1970 Namibia advisory opinion. The court held here that the title of a state over a particular territory is not a prerequisite for the extraterritorial application of human rights law, but that the state's physical control over said territory is sufficient. Consequently, the relationship between IHRL instruments and the content and language of the national constitutions of various countries is apparent. Firstly, the human rights language is especially common in countries most susceptible to global influences, and not just limited to developed or democratic states. Secondly, human rights language is driven by the extent of the international human rights regime at the time of a constitution's writing. Third, human rights language tends to appear in newer constitutions and in the constitutions of emergent and reorganized states. So where national constitutions are imprinted with global social conditions, many countries founded after the Second World War have visible human rights influences within their constitutions. For example, Burundi or Cambodia, adding a universalistic tone to the Convention on Rights anchored in national mechanisms. National experiences have been the main driving force behind this incorporation. However, the adoption of national human rights language in national constitutions often serves as a general narrative rather than a set of practical legal guidelines. So what is a constitution? Well, constitutions are agreements on rules and ethics by a specific nation. They are a formative document of basic principles and laws of a nation, state, or social group, determining the powers and duties of the governing and guaranteeing certain rights to the governed. Constitutions represent the foundational instrument within nation building and the formation of communities and societies, establishing rules, specifying powers, and outlining the rights and obligations of all involved parties. In interpreting constitutions, there exist two forms of constitutions in reality, one written and one unwritten. A written constitution is one in which all rules and regulations are written in well-documented form and at one place. An unwritten constitution pertains to one in which the rules are not strictly documented in one place. The difference, therefore, between the two is that a written constitution has all of its principles consolidated in a precise manner, and an unwritten constitution has scattered principles. So there exist several common elements within the constitutions of liberal democracies. First, the separation of powers, where power is divided amongst the legislative, executive, and judicial branches. Second, judicial review, where courts are empowered to invalidate laws as unconstitutional. Third, federalism, where government power is spread between the state and federal governments. So human rights are at the heart of the constitutional order of a modern state, not only determining relationships between the individuals, groups, and the state, but also permeating state structures and decision-making and oversight processes. Constitution-making processes are a central aspect of democratic transitions, peace building, and state building. The ability of participants to articulate their views freely and participate without discrimination in the formation and adoption of a constitutional order ties with the ideal of human rights. Further, within liberal democracies, acting in accordance with the Constitution means acting in conformity with human rights and fundamental freedoms in a fair and just manner. So comparative constitutional law explores the nature of constitutional government by exploring how constitutional arrangements of different states frame and discipline the exercise of public power, considering the foundations of constitutional law, the idea of constitutionalism, and constitutional principles. This provides the structured method by which governments may create foundational documents, including a Bill of Rights from Mars. There exist four principal uses of comparative constitutional law. First, uses of foreign constitutional materials in constitution making. This is understood as encompassing such international instruments as the Universal Declaration of Human Rights, the UDHR, within constitution making, revision, or amendments. Second, use of foreign constitutional materials in constitutional interpretation. This is in the hands of actors or participants in the constitutional area. Third, providing descriptive accountings concerning the content of debates and correspondences preceding the formal adoption of a constitution. Fourth, elaborating the normative assessments of participant dealings with comparative constitutional materials. So in essence, examining the goals, motivations, or intentions of the drafters behind the Constitution. So the purpose of comparative constitutional law herein is to search for the universal, that being the basis of what can be empirically observed or of conformity to the ideal liberal constitutionalist arrangement. It seeks to identify and highlight common or universal principles and determine how particular constitutional jurisprudences conform to these principles. So what is a Bill of Rights, though? A Bill of Rights is a document that contains a formal list of the rights of a citizen in society, which a society regards as being fundamentally important to its citizens. Its purpose is to list and provide protections for these rights. A Bill of Rights can be entrenched or unentrenched. An entrenched Bill of Rights is contained within the constitutions of a country, meaning that it cannot be changed by a mere legislative act, but only by a referendum. An unentrenched Bill of Rights is an ordinary act of parliament which can be altered or repealed by the legislature. So the common rights encompassed under a Bill of Rights include freedom of religion, freedom of speech, expression, press, freedom from unwanted and unwanted government intrusion, the right to be treated fairly by the government, and the right to be treated equally before the law. The formation and interpretation of a country's Bill of Rights should consider international human rights standards. As an example, the UDHR has served as an inspirational document for many national constitutions, with its values and principles having encouraged and inspired many constitutions in promoting human rights across their national constitutions and Bill of Rights. Under IHRL, a Bill of Rights should therefore prevent the adoption of laws which may result in discrimination against or social inclusion of individuals or specific groups. Further, the principle of pacta sunt servanda, agreements must be kept, requires that a Bill of Rights be consistent with the human rights treaties ratified by a state. So a Mars settlement may wish to emulate, for example, the US Bill of Rights. Within the US, there was initially no Bill of Rights in the Constitution. Consequently, the desire for people to have a guaranteed rights that could not be overridden by the government gave rise to amendments to include fundamental rights, comprising the first 10 amendments to the Constitution. The US Bill of Rights guarantees civil rights and liberties to the individual, i.e. freedom of speech, sets rules for the due process of law, and reserves all powers not delegated to the federal government, to the people, or to the states. The degree of entrenchment of these rights within the US Bill of Rights is strong, highlighted by the scarcity of the amendments to the Constitution and the difficult process of amending the Constitution. It is the US Supreme Court that decides constitutional issues and interprets the meaning of the words in the Bill of Rights. In short, the US Supreme Court determines the extent of the rights presented by the words in the Constitution. Further, many of the rights in the Constitution are relevant and equivalent to the rights found in the UDHR, especially those related to political and civil liberties. Conversely, a Mars settlement may wish to emulate the UK's approach. Within the UK, there does not exist a Bill of Rights concerning the rights of citizens. While there does exist a Bill of Rights of 1689, this document was concerned primarily with limits on the powers of the monarchy and protecting the rights and activities of the English Parliament from royal interference. Where the UK also lacks a written constitution, this presents an additional barrier to the formation of a Bill of Rights. Its constitution is instead derived from the laws covering human rights, freedoms, and civil liberties, which come from a number of different sources, including case law and statute. In the absence of a Bill of Rights, the UK has adopted an external foundational document instead. Herein, the European Convention on Human Rights has provided a list of rights and freedoms to the UK more extensive than those set out in the US Bill of Rights. Finally, within Australia, there exists a written constitution, but the country does not have a Bill of Rights. It is the only Western democratic country that does not have a Bill of Rights. In lieu of this document, Australia's constitutional law doctrine protects citizens from governmental interference and laws passed by Parliament. As an example, the freedom of speech and political communication is based upon the common law doctrine of statutory interpretation. Herein, such rights draw upon the system of responsible and representative government as implied within the text and structure of the Constitution. Written rights have the benefit of being clearer, but are less flexible to change than implied rights. So as observed, the lack of a Bill of Rights is no barrier to the foundation and stability of a liberal democratic society. For Mars settlement, a constitution alone may suffice, accompanied by a strong judicial review to advance the individual rights implied therein. Further, in determining legal frameworks to be applied across isolated human settlements in outer space, an anthropological perspective draws attention to the historical experiences during the Age of Exploration. During the British colonization of Australia in the 18th century, the establishment of the initial penal colony of New South Wales fell under the governance of military law. However, this would later be accompanied by the formation of a Charter of Justice, outlining basic principles and upholding the rule of law. So noting how a foundational document was formed by local administrative authorities in Australia after its initial colonization, it would therefore be presumptive of terrestrial governments to author a comprehensive foundational document, where these documents may lack an awareness of local conditions on Mars, may have fallen out of date, and whose imposition may be viewed as oppressive upon Martian colonists. Consequently, a more suited approach here may be for the provision of a basic set of principles drawn from human rights to guide colonists in the creation of their own conception of such foundational documents. The intersection of IHRL, International Human Rights Law, and ISL provide the means for translating terrestrial values and principles into the domain of outer space and supporting humanity's endeavors among the stars. There exist two approaches herein. Firstly, the use of space applications in supporting and realizing of human rights duties and obligations on the Earth. Secondly, the development of human rights values and principles in the advancement of human activities in outer space. So in focusing upon this second approach, attention is directed to Article 3 of the 1967 Outer Space Treaty, specifying that activities conducted by states parties must be conducted in accordance with international law, including the UN Charter. Consequently, in whatever space activity a state undertakes, such an activity must be in accordance with international law, which is relevant and applicable. This therefore challenges states to take the lead in interpreting how IHRL is pertinent to space activities, referencing including in the formation of foundational documents for Martian settlement. Finally, the UN Charter references human rights in its preamble to reaffirm faith in fundamental human rights in the dignity and worth of the human person. Accordingly, each member state carries the positive duty to comply with the terms of the Charter, including across their activities in outer space. Where ISL guides human activities in space, several notable ISL elements and principles may prove relevant in the drafting of foundational documents. Firstly, the term province of all mankind, as referred to in Article 1 of the OST, eliciting the notion of intergenerational equity and sustainability. Second, the due regard principle in Article 9 of the OST, requiring consideration on how one's activities may impact upon others. Finally, peaceful purposes, as outlined under Article 4 of the OST, emphasizing the need to maintain international peace and security in outer space. So in creating foundational documents, that being a Bill of Rights or a Constitution for Mars settlement, the drafters should not only make sure that the instrument does not explicitly contradict IHRL standards, but also avoids formulations that could be used as a basis for any legal interpretation contrary to those standards. Having considered the values and principles embodied in various IHRL instruments and several national constitutions, the creation of foundational documents which will guide the governing of future Martian settlements must incorporate the following core principles. Firstly, checks and balances, preventing injustices and the corruption of power by empowering separate branches of government to prevent actions by other branches. A just and fair government must divide power between various branches. Second, popular sovereignty, recognizing that the power of government comes from the people. Third, due process, where the government must interact with all people according to the duly enacted laws and then apply these rules equally with respect to all people. Fourth, equality and non-discrimination, recognizing that all persons have the same rights and ensuring that no one is denied their right because of their race, language, religion, or otherwise. Fifth, liberty, except where authorized by citizens through the Constitution, governments should not have the authority to limit freedom. So human rights therefore have much to offer in promoting future human settlements on the Martian surface. Firstly, the right to own property is recognized under Article 17 of the UDHR. Incorporating human rights principles within the Constitution, therefore, will make constitutional making will contribute to a balanced and concise understanding of the rights of the individual versus that of the larger community concerning resources integral to human health and survival in outer space. Second, maintaining the rule of law is relevant to equality, non-discrimination, and fairness. Recognizing human rights within constitution making will preclude the possibility of discriminative actions and conflict arising over essential resources, including the course of civil disputes between private parties and broader government policy. Third, safeguarding human dignity is relevant in ensuring the provision of resources and services essential to human existence and individual personhood. Fourth, promoting sustainable practices and environmental responsibility in precluding and managing the acquisition of essential resources from the environment, noting that environmentally destructive potential of activities associated with the mining and collection of natural resources on celestial bodies and within the orbital environment as well. Finally, contributing toward the establishment of a framework that holds local governments accountable, helping prevent abuses while also providing recourse for countering injustices. This will hold governments accountable to their obligations to respect, protect, and fulfill fundamental human rights. So that marks the end of the presentation. Thank you for joining me today, and I look forward to your questions.
Awesome. Thank you so much. We're going to go ahead and start the Q&A portion of the meeting. And we're just going to pull up a couple of the questions from this chat. Rob McIlver asks, in the high cost of Mars exploration and settlement and the necessary dependence of Mars settlements on Earth-based governments and non-governmental organizations supporting them, will there not be off-planet stakeholders other than the citizens of the Mars settlements whose rights and prerogatives will have to be taken into account in the development of governance structures? And are you really hypothesizing complete political independence for the Mars settlements?
So, high cost of Mars settlement exploration. All right, so firstly, there will indeed be a number of off-planet stakeholders, and it's important to also consider within a national constitution and the Bill of Rights as to how you will protect the rights of not just your citizens, but also foreigners. So for example, you have the United States, which its constitution and its Bill of Rights protects the political freedoms of people who wish to protest in the United States, even if they're not citizens. However, if you look at other countries, say like Singapore, if you try to protest there, you will be jailed if you try to express any political opinion and you're not a citizen. So it's essential that a constitution considers the rights of both its citizens and of people not of the locale. And to your second question regarding complete political independence for Mars settlements, it's really a question of how will you maintain the link between terrestrial governments and isolated human communities across the final frontier given that you have the challenges of immense distances and time lag in communications, and unexpected things may occur as well, which can compromise the survival of such a settlement. So the whole concept of a bill of rights and foundational documents and human rights here is to create the common link and maintain this common link with the Earth and terrestrial governments, and to maintain a common human identity. In some circumstances, they over the course of eons, who knows, people may evolve to be different, and the idea of how these rights may apply to them may evolve as well. So it should be fluid. Yeah. Next question.
A couple questions touched on the nuclear laws and nuclear non-proliferation treaty, and do you see that as being a potential problem or an issue?
So nuclear non-proliferation treaty. So from what I understand of outer space and weaponization, and the outer space treaty prohibits the use of weapons of mass destruction in outer space, and the stationing of them in outer space, be it nuclear, chemical, or biological. However, it does not prohibit the transition through outer space. So that's why people can still use ICBMs to kill each other. But also, it does not wholly prohibit the stationing of and use of conventional weaponry in outer space. And that's what they're looking to deal with at the moment in UNUSA with regards to prevention, the prevention of an arms race in outer space. And we'll see how that goes. Next question.
Christopher Dorner asks, what do you see for citizens born on Mars rights on Earth, as they wouldn't be citizens of a specific nation, or would it be the nation of their parents?
Yeah, so within international law, you have a few answers to this. So, for example, within the United States, you have jus soli. So that's where wherever you are born, if you are born in the United States, within United States soil, you must automatically become a citizen. However, you have other countries, such as Australia, where even if you're born here, you do not automatically become a citizen. Instead, you take the citizenship of your parents or otherwise. And within the near future, where you would possibly have people being born in space or on Mars or on the moon, then it flows that their nationality would be applied to their parents, or to where the vehicle is registered, or whose particular territory you're being born upon. Yep, next question.
We have one question from the Eco that asks, if Mars and Earth initiate a war, is it possible to evacuate as refugees?
Someone's been watching The Expanse too much, I believe. But that's more of a technical question than a human rights question. If such an event were to occur, I believe that the international humanitarian law instead would apply in that instance, with regards to how you would accept and protect the rights of refugees. That's also covered under one international convention on migrants as well, and refugees, I believe. So this provides a framework in managing the movement of people across various jurisdictions and borders. Next question.
We're actually out of time, but Jonathan Lim, thank you so much for joining us today. And thank you everyone for joining us on this call.
No worries, it's a pleasure. Thank you.